Okay, we're recording. Hello, everybody. Welcome to another episode of Mentors on Tap. We're going to talk about everybody's favorite topic today, GDPR, General Data Protection Regulation out of the EU. And if and how it applies to us, and to what extent. We'll start it with the good news. It's not as bad as it seems at first glance. Got my buddy Steve here, Steve Gerinxer of Steam Driven
Hello,
Media.
everybody. So let me start by asking all the stupid questions because I have paid zero attention to this. I don't have the bandwidth in my brain for it right now. So GDPR, from what I understand, is basically you have to protect your site visitors' privacy. Plain and simple.
Yeah, it is. It starts with the very basic aspect of the fact that your personal information, regardless of who manages to get it and how, whether you gave it to them or they bought a list or what, that's always your property and you have total control over it. And that is a stumbling block for a lot of these marketers out there that have thought, well, I paid good money for this list and this information is mine to do with as I choose.
Well, that's kind of a stumbling block for basically everybody on the internet because the customer has, or the product has usually been the people who visit your website, especially for companies like Google or Facebook. You're not a customer, you're the product. And that would take their entire business model. And if you want to say, no, you can't have my personal data, obviously they have the right to say, well, then you can't be on our site. But I mean, how far does that go?
Well, I think that's what we're faced with, is trying to change the mindset a little bit. I've got a client right now whose solution, they're U.S. based, and their client base is U.S. and not even in Canada, just in the United States. So their solution was to simply IP block anything outside the United States.
Sure.
They can't see the site. And yes, that is a solution, but it still has an impact on the business. It has an impact on the business from the standpoint that every client they have is not always going to be sitting in the United States. They may be on vacation or on business trip to Europe. They may be in Canada. They may be simply missing some. There's a potential for some impact there in terms of loss of interaction, even impacting their searchability. Because if they're losing some of this impact that a European user might bring to their site, what effect might that have on their search rankings? So we could probably get in an argument over that. I have mixed emotions on that. I do think that since they do have the potential, there are companies that are opening up offices. They're based in the EU and they're opening up an office in the United States. So they're going to be researching. They can't. You're not even a player. You don't exist. So
right. I
think that's a poor solution, at least for this particular client. For most of them, it's just we're going to have to change the entire mindset.
I would think that if you're like a small mom and pop that's local, maybe regional, this is probably going to have no effect on you.
For the most part, yeah.
Until the United States passes their own versions of these laws.
Well, that's the other thing. We've got the CCPA, the California Consumer Protection Act, has already been passed, and that's going into play on 1 January. New York is getting ready to pass something that's going to make the CCPA look pretty tame. It's going to be the most stringent yet. Nevada's got one, Michigan's got one. Canada is presently entertaining, I think it's in their parliamentary committee. So, it's the direction things are going. There's going to be a requirement for all companies, even if it's just an informational blog. If you're, just publishing your family recipes, if you have visitors coming from any of these jurisdictions, and you're doing more than simply implementing the essential for the functions of the site, essential cookies, you're going to be required to meet one of these regulations requirements in terms of notification, making them aware of what data you're taking and what you're going to do with it, and giving them the option to delete it or modify it or limit the processing that's applied to it, whatever. So, you know, it's
So
common sense and common decency.
more pop-ups that will read.
Well, you know, the biggest thing I keep running into, people, they go, you know, they got a WordPress site, so they go to the WordPress plugin repository and they find something that calls itself GDPR plugin or GDPR compliance, and they think, oh, this will bring me into compliance. And they're not. They're a tool to satisfy some requirement of GDPR. It's like, you know, I'm going to put this additive in my gas tank, so now my car will be, I'll get 10 more years use out of it. You might, right, but it's a tool. It's, you know, it doesn't preclude the rest of the maintenance you got to do to your car. So anyway, you said you had a stupid question. I came up with a stupid answer. Your turn.
Okay, so if, let's say you're one of these, you're a website that's a national company, international company, and I mean, a lot of us have worked with those over the years where, you know, they have clients in Europe and whatever. Even some of the small mom and pops have customers in Europe and stuff. What kind of things are they going to be required to, I mean, let's say somebody says, I want you to remove all my data. I mean, if you're using a third-party credit card processor like most people are now to get away from PCI compliance issues, how do you deal with that?
Well, first of all, yeah, you know, if you're doing business with people in the EU, particularly, what makes it obvious that you're doing business, if you're marketing to them, if you're publishing any information on your site in their language, to their servers, let's say a .nl or a .uk. If you mention them even in one instance, it was so simple as free worldwide shipping. That basically made them liable for compliance under GDPR. The ICO found it. You know, they rendered a decision to that effect. So if you're doing anything with EU clients, you're going to have to come to comply. Now, the amount of compliance varies a lot. If you're a large corporation and you've got, you know, 500 employees, you're probably going to, well, you will have to have what they call a DPO, data processing officer. This is going to be a dedicated function. This person is responsible for being the contact point, for ensuring compliance, for being the interface between you and the commission, between you know, your company and the users. They're responsible for all aspects, and they're going to be the primary point of contact. Much like if you start a Delaware corporation in Oklahoma, you're going to have a legal representative in Delaware. This might just be the attorney who helped you get the corporation set up to begin with. Same sort of thing. You're going to have a representative, but you're also going to have this DPO. Now, there are instances in which it can be a person who has other duties, but the DPO functions must be their primary duties, not collateral duties. And B, there can be no conflicts whatsoever between their DPO functions and their other duties. So this person has to be independent. The CEO cannot override them. They get to mandate, these are the things that we must do to comply in this particular situation. They're responsible for all the record keeping. So for some companies, they won't, you know, if they're 50 employees or 3 employees, they don't have to have a DPO. They can assign somebody in-house as the primary contact. And in that instance, as long as that individual is told that their data compliance responsibilities take precedence over everything else, you have no problem. So you don't have that additional employee and all the overhead and additional expense that goes with that.
I can see some very large turf wars internally in companies coming about because of this stuff.
Absolutely.
Especially when you start looking at a DPO versus a CFO, or not a CFO, but a CTO, where you've got your IT and your technical staff, all of a sudden are now technically subservient to their data protection person.
And this is precisely why the regulation was drafted the way it was, to try to preclude those turf wars as much as possible. This person has to have ultimate authority. And if you're the DPO and you say, okay, here's something we have to do, and the CTO or CEO or whoever vetoes it, then as the DPO, you're required to report to the supervising authority, to the commission, that we're not going to comply with this. We're not in compliance. So that's going to trigger an audit, and that's going to, so the DPO could be legally culpable for failing to report, for failing to enforce. So, who wants to put themselves in that position?
Not me.
And it's not a job that anybody is going to be eager to have, anybody in their right mind at least. So if you're going to hire a DPO, you're going to have to pay them pretty well.
I can think of a lot of people who would love that job.
Well, I can think of a lot of people that would love to be able to jam something down their CTO's throat, but
yes. But just in general, I can think of a lot of people who would love to have that level of authority and responsibility, yet not actually have to do the work.
Yeah, I'm sure there'd be a long list of those folks. Yeah, well, I think we've met a few of them. So, the impact for the average business of, small business is going to be basically they have to make the users aware of what information they're gathering, make them aware of their rights, and give them contact information so that if they want to alter, delete, get a copy of, just view whatever their information, they can do so. And then keep records, okay? This is where it becomes a bit of a chore for most organizations of any size. You have to have a record of the fact that Steve visited my site, gave me consent to send him marketing information, or signed up for my newsletter or whatever. And here's a record. Here's when he did it. Here's the date he did it. And here's the mechanism by which he did it. And I keep that, okay? Now, the beauty of it is, if you have a WordPress site, for instance, and actually for most sites, this wouldn't be much of a chore, even if they weren't WordPress. WordPress has built into the core now the ability to export data, to search data. So if a given user comes to you and says, I want my information, I want to see it, I want to modify it, I want to delete it, it's right within the WordPress core, that function exists. If you're not a WordPress site, it's the matter of your CTO is just going to have, not your CTO, your IT guy is just going to have to go into the logs and find the data for that particular individual so that it can be extracted and deleted.
Being of the mindset that I typically am, I can think of a lot of ways that a competitor could abuse that horribly.
Yeah.
Just by continually sending requests from various email addresses and names. What data of mine do you have?
Yeah.
Just that simple request, because each one of those is going to take time to research.
Well, it can be relatively easily. It can be automated. You can actually even do it to the point where a user, if they have an account or any sort of credentials on your site, they can actually, using a cookie, they can actually query this information themselves, and the system, the IT guy would be made aware of it, but he wouldn't have to be involved in the process at all. So it's not that big a deal. But the thing is, where a lot of people balk at it is that it's something somewhat different that they have to have. The problem is, if you ever do get in Dutch, if somebody files a complaint and the commission or whatever supervising authority you're under decides to take a look at you, if you don't have that record keeping ability, you are automatically in the hot seat. Because, I mean, face it, how can you possibly claim to be protecting their data when you can't even see what data you have, much less help them satisfy their rights to edit or delete that data? So that's a problem. And it's
Yeah.
not insurmountable by any means. It's not nearly as much of a bugaboo as it would appear at first glance, but it does take some attention.
I just see that as yet another layer of pain in the ass for site developers and relatively small websites who maybe they do international stuff, but they sell a single item.
Well, there are in various areas of the GDPR, there's wording present that, for instance, refers to occasional. Okay. Now,
Okay.
let's say occasional processing. If you're making 200,000 sales transactions a month, and typically one or two of those come out of the EU, that would certainly fall into the category of occasional. And this lessens greatly your responsibilities. You still have to allow those people to exercise their rights under GDPR. But
Mhm.
the fact, for instance, if Frank Parolini from Naples is visiting an uncle in New York City, and from Brooklyn he accesses your site. Okay, he's an EU citizen. You're now in possession of his data. Technically speaking, that puts GDPR requirements upon you. But if that's a once in a blue moon type thing, it'll certainly fall under the category of occasional. Your responsibilities are greatly limited. You still have to make every user aware of what you're doing with their data, because you're not just really dealing with GDPR. Like I say, you have all these other regulations that have been or will soon be implemented that are very similar. So, the common sense stuff is still going to apply. The nuts and bolts of it may vary quite a bit. But yeah, you're right. There is the potential for abuse. I mean, I can see somebody, using a automated program to generate 10,000 emails or entities to visit the site, grab the cookie, and then send takedown requests, for the data that would put a hell of a burden.
More of a Mechanical Turk or a Fiverr gig, but
Yeah.
Not that anybody has never done these kinds of horrible things to another company's
Oh, of course
websites.
not. No. Well, the other thing that GDPR, for instance, mentions is they make it available to you to, you have to let me have a copy of my data free. Okay. But if I ask for it 4 times a year, it no longer has to be free. Now you can apply a reasonable charge to it.
$1 million.
Well, that reasonable is always subjective, right?
That's reasonable to me.
But you have to give it to them free of charge within reason. But if they're hitting you every month for this stuff, that's no longer reasonable. It no longer has to be free. So if you're charging $25 or $50 for the additional processing, that would probably fly.
It would be similar to the photocopy fee that you have to pay at the county courthouse when you want public records, or from a lawyer or a mortgage broker or whatever.
Yeah, that charge has to be somewhat justifiable. A reasonable charge. Like I say, it's subjective, but $1 million isn't going to fly. But $25, $30 probably would.
I'd go 50, but yeah, I can see that. But still, it's just so. We don't want to spend. We're already about 20 minutes in. Let's say you're unsure what you should be doing. You're reasonably confident you don't have to worry about it too much. But what small things could you do with your website now to kind of mitigate any future problems for, let's say, a small mom and pop? Is having a pop-up that says, we use your cookies and this is how we use them. If you say yes, click yes or no. And if you click no, then all of a sudden I send you to an AMP version of my website that's completely gutted and worthless. Or to, where are we at with that?
Well, there's 2 basics that any site should have anyway, in my opinion, and certainly needs to have if they're going to be subject to any of these regulations. One is a cookie policy. You know, the first time they visit your site, there should be, for instance, a pop-up or a banner that says, these are the types of cookies that we gather, that we put on your host, on your machine, and this is why, and give you the opportunity to opt in, not opt out. They can't be pre-checked. They must be requiring an affirmative action on the part of the user to opt in. And the other is a privacy policy. The privacy policy basically, you know, there's a million different templates out there. You simply have to state how you're going to handle data. When are you going to make it aware, make the users aware of what you're going to do, what changes might occur, and how they'll be aware of. That privacy policy must have an effective date or last changed date, whatever, on it, near the top, ideally, that tells them that they're looking at current information. So cookie policy, privacy policy, which kind of go hand in hand. If you're on a WordPress site, there are 2 or 3 very good cookie plugins that will provide you with this information. I stress that most of those come defaulting with certain blocks pre-checked. Uncheck those boxes when you do the setup of your cookie. They must not be pre-checked. And there are a number of privacy policies available. Any of you guys that are watching this, if you need some recommendations for either of those, reach out to me. I can give you some plugin names and point you to a couple of good templates.
Probably convince Doc to do a small blog post to go along with this video, mention, you know, with the list of these, and
yeah,
some thought on that.
Yeah, we can add some of those plugin names and a couple of privacy policy. In fact, you can go to our site and look at the privacy policy there. There's, you know, you'd obviously have to edit it to fit your situation, but it's a good basic privacy policy. And hey, if you have questions, reach out to me. I do GDPR compliance audits. I do not consider myself an expert, a guru in that. You know, there's a lot left to learn about it. And a lot of what's going to have to be learned is going to be because of what actions the commission may take as they find violations. You know, some of it's still kind of like with Google. You know, we have to wait and see how they interpret certain things, because there is some gray area in a couple of areas that are open to interpretation. So it'll be wait and see on some of that stuff.
So basically, if you're a small to mid-sized company who doesn't really do any international, this should be on your radar and something you should be aware of that's coming, and start being proactive about it. But if you are already an international company, you are late to the game and need to get off your ass and start doing something.
This was implemented, it was made effective in May of 2018. So, you know, they are actively pursuing the most flagrant violations and the active complaints that have been filed with them. And you know, nuisance complaints is another negative that could happen by some evildoers out there. Just to, you know, especially if they see that you aren't in compliance and they file a complaint, they may nail you to the wall. Even if you are in compliance, they could file a complaint and get you unwanted visibility, or the nuisance of having to respond. So it's like an IRS audit. You may be clean as a whistle, but audits are not fun regardless.
So people filing nuisance complaints against other companies just to cause them drama. What's the world coming to?
Yeah. But I would certainly say that, you know, a good first step for any business, small, medium, or large, is to familiarize themselves. I have a searchable copy of the entire text of GDPR, as well as the CCPA, on my site, intrinsicvalueseo.com. It's in the top nav. You can go and you can read through there, and you see it's written in a way that's fairly easy to understand. They tried to keep as much of the legalese out of it as they could and still have it be a legal regulation. But there's not a lot of conflict in it. It's fairly cut and dried. It's just an awful lot of reading. There's like 170 recitals and 98 or 99 articles. So
Yeah.
It's not something you're going to snap through at lunch.
That's where your dedicated privacy officer comes into play.
Well, and I've got clients who have a dedicated DPO, and these guys are spending all day, every day, trying to stay up on stuff, looking at current cases. I mean, just like we do in SEO, you have to be watching every minute because things are changing all the time. More definition is coming out, and there's a lot to learn.
Right.
And
Wonderful.
again, like we've all faced situations with clients where another department does something in good faith, out of ignorance. They don't know, so they do something that suddenly takes you out of compliance in some area. This is why
Or not.
training becomes an issue. The other thing is that the information that you do hold, it can't be available to just anybody in the company. It has to be rather tightly held, and you have to have documented who has access to that, so that if there's a breach, it can be traced.
So I mean, I know we need to be wrapping up here shortly, but I was just thinking about this. I have another client who asked me about adding this to their website, where you have a ticker in the bottom corner somewhere that just says, Angie G just purchased our whatever.
Yeah, no. That'd be a
That
big
is
no.
huge. That is huge in some markets because they use that as a social proof that they're safe to buy from, because you're constantly seeing somebody's first name, last initial, and what they bought.
Yeah, no.
Run away. Run
Unequivocally,
away. Okay.
dude, run, don't walk. Yeah, that's no. I suppose you could conceivably get away with it if you use an anonymized, user number ABC 1215 just bought, but
Yeah,
even
but
that
that doesn't convey any social proof.
yeah,
Because
exactly.
it's not. And yeah, I can see where your conversion people and your privacy people will go head to head on this, because the privacy stuff is going to hurt conversion rates, because there are things that we do to improve conversions that are very personalized.
Yeah, I mean,
So,
you could get consent from users to do things with their data, and I mean, conceivably, you could ask them for consent to do this, but who the hell would give it?
well, then now of course, now this has me thinking about all these people who do reviews on, let's say, a GMB page, and then you pull that review into your website, and it's got their name and a link to their profile, but that's stuff that they volunteered to, basically Google on your business page. But does that change? Does the privacy rules change because now you've pulled it onto your website?
That's a real
Or
good question. I wonder about that. If you simply pull it in, doing an import, so that it actually, you can click on it, it would link you back to GMB.
right.
Then maybe not.
Maybe.
I don't know. That's a good question. I know just
I
who to
really
ask
do.
of that. I know an attorney who deals in this a lot, and I will ask her because I bet she'll know. That's a good question.
I mean, pretty much every website we build has some sort of functionality where
Yep.
reviews and testimonials are pulled in automatically.
Well, even to the point of somebody commenting on your blog. They comment on a blog post using their gravatar. Okay,
Oh.
I don't know. That's not a question I have seen addressed. I do think that. I think the prudent way to approach that would be is when somebody wants to make their first comment, you present them with an opportunity to opt in. You have to understand by authorizing the ability to make a comment on our site, you are authorizing us to use your username or gravatar, or if you sign in using Facebook, and to me, log in via Facebook or Google is no longer an issue. I no longer accept that as an option.
See, I've been the opposite. We have almost across the board, anywhere where we allow commenting, we use Facebook plugin APIs for that, so that we don't have to manage the login process. That all happens by Facebook, but it also ties a real person to a real name, so we don't have to deal with all the spam. And if done properly, then all those comments appear on the post on Facebook and on the blog.
Yeah.
So, yeah, I can see a lot of ways where GDPR could mess with your head.
Yep.
This is going to be, the next few years will be entertaining with some of the stuff.
Yeah. It will not be boring.
Well, will it be financially lucrative? For someone, probably.
For somebody. I think it's a great opportunity to remind anybody that might be watching this that part of the heart of Mentors on Tap is questions.
Yeah.
So, go to our Facebook page, go to our website. We have, ask@mentorsontap.com is the email that we accept questions as well. If you have questions about GDPR, about particular situations, by all means, send them. We can answer them. If we can't answer them, we can find somebody that can.
And I'm sure this is a topic we will revisit over and over as it evolves and grows and we learn more about it. Because I don't see this as one of those things that's going to go away anytime soon.
No, I think we're going to see it expanding. Like I say, there's various states in the United States that are already in committee with bills, if they've not already passed. And CCPA, like I say, January 1st takes effect. So that's going to be interesting, because now if you're in Omaha and you have any users in California, this is why the federal Congress is presently entertaining. There are a couple bills under preparation to be submitted to committee, because having all these different requirements by 50 different states makes it almost impossible to do business safely in the United States, because you don't know where somebody's logging in from.
It's sort of like expecting the average website to collect and reimburse sales tax.
Exactly.
For all the various tax entities across the United States, where I'm obviously not a huge fan of large federal government, but anytime something happens that could potentially cross state lines, I feel that's an area that the states have to stay out of, and the federal government has to step in. And if California wants to make a law for California citizens based on California businesses, great. But if they want to, we've seen it so many times in the past where jurisdictions on the other side of the country with completely different rule sets go after people because they can. And that's a bad thing.
Yeah, this is one of those areas where I think we really need to have a common standard across the country, as a minimum at least. And I don't think that it probably should be more defined as just this is the standard, not as a minimum. Because if it says a minimum, California can just come in with something that's more stringent. And there's I forget what the term is now, but there is a standard of states supposedly not being able to be more stringent than a federal law. But it gets ignored all the time. Until it gets to
as we run down a side path, we have the same issue right now with the EPA in California and the current administration saying that California EPA regulations can't apply to everybody else or whatever. But which I kind of get. As a manufacturer, it's a pain in the ass to maintain two sets of standards.
Sure.
So in general, the manufacturers build towards the most strict standard, which gives one small state an awful lot of power. So yeah, I can see that. This is going to be like I said, it's going to be entertaining, and it's a topic we will probably end up revisiting on a fairly regular basis as it evolves. So yeah, if you have any questions, please send them to us. Doc is happy to research them and answer them for us. And we can all learn a bit more. And if you have questions on any other topics, not necessarily business or not necessarily GDPR, but whether it's business or employee related, whatever, there's a vast wealth of knowledge that can be tapped, and we seem to know a lot of people who are really good at things, and we'll be happy to bring on guests that know more than we do, which would be a fairly regular thing. And we look forward to hearing from you guys.
Absolutely. So until the next episode, thanks for tuning in. Hope it was worth your while.
Have a good one, everybody.